USA.
Welcome back. Well, my guest I lined up yesterday because I was certainly expecting this ruling to come down from the High Court. Hans von Spakovsky, he is the senior legal counsel for Advancing American Freedom. Hans, glad to have you on board.
Well, thanks for having me.
Well, I wanted you because you are a constitutional legal expert and also federal election expert as well. But let's deal with the SCOTUS ruling, basically that anchor babies are entitled to birthright citizenship, 100% American. Did you expect that ruling and your reaction to what you've seen and heard so far?
Well, I was pessimistic that we would get a ruling like that, although I was hoping that it wouldn't be quite as, frankly, extreme as it is. Once again, it's Chief Justice Roberts writing the opinion, and this is probably the second worst mistake he's ever made. It might be the first, the other one being his mistake in the Obamacare case. But those are... This decision and the one in the Obamacare case are probably two of the worst decisions by the U.S. Supreme Court in the last 50 years.
Now, some are going to say you're speaking on political issue. You're not looking at it as a constitutional expert.
No, but that's wrong. In fact, Roberts gets the history and legislative background of the 14th Amendment. He gets it completely wrong. In fact, the dissent by Thomas and the dissent by Alito completely eviscerates the majority opinion and points out all of the mistakes that they make in supposedly laying out the history of the citizenship clause of the 14th Amendment. I mean, if you want a good exposition of the actual history, you read the dissents in this case, not the majority opinions, but they're just wrong.
Well, it's a 194-page decision saying Trump's order violates the 14th Amendment of the Constitution. And again, 6-3 vote. And Chief Justice Roberts said citizenship then and now was the right to have rights. So what's the argument the other side that should trump it but did not?
Well, he completely ignores what the sponsors of the 14th Amendment said. They said that this was a two-part provision, and that you not only had to be born in the United States, but you had to be within the jurisdiction of the United States. Now, Roberts just says, if you're born here, you're within the jurisdiction. That is not what that phrase meant to the sponsors. They said what that meant was you owe your political allegiance to the U.S. government. And clearly, the child of, for example, a tourist who's only here for 2 weeks, has the baby, and then leaves, that child doesn't have any political allegiance to the U.S., isn't within the jurisdiction of the U.S., and Roberts just kind of glances over that. And again, Alito and Thomas point out just how wrong he is in his recitation of the history of this provision. The odd thing is Kavanaugh concurred in the judgment, but then said, well, he doesn't think it violates the 14th Amendment. It violates a federal statute. So he hints that Congress could potentially change the statute. So that's basically four justices who are saying that the 14th Amendment does not provide birthright citizenship.
Now, again, it was put in place in the 1800s. It was entitled or intended to protect slaves who were brought here against their will and had children here. That was the origin of it. But that was the 1800s when we were more isolated by geography, and now, we got air and mass transit and so forth that has changed the face of the world, much less our nation. It is an entirely different world, but does that detract from what the founders intended?
The fact that it's a different world today, you don't even need to take that into consideration. If you go back to the original understanding of it, it does not do what Justice Roberts said today. Unfortunately, also, once again, joined by Amy Coney Barrett, who appears to be turning herself into the new Justice Kennedy of the Supreme Court.
That's a good point. You're listening to Hans von Spakovsky. He's a senior legal counsel advancing American freedom. Well, I pointed out to the audience, we're not the only nation that has this. About 33 plus U.S., Canada, Mexico, Costa Rica, South America, Caribbean. So we're not the only nation that has this, but I don't see it so much in Europe.
No. In fact, it's only a small minority of countries that have it. And some countries that had it, like Australia, got rid of it because they realized what a mistake it was, because it provided citizenship to people who really are not fully loyal to and are not part of the culture and society of a country.
Jonathan Turley, Fox News analyst, George Washington professor, says, well, the remedy, the next step would be ratification, to the Constitution. Do you see that possibility?
Yeah, I think the only way to really fix this is a constitutional amendment. That would cause a particularly fierce fight between the red states and the blue states, assuming you could even get it through Congress.
And it has to go through Congress before it can even go to the states for the 3/4 of them to approve? Okay. And again, as you said, that's there is a constitutional convention option, but that's never been used, has it?
No, it has never been used, although there's been a movement in recent years to hold a constitutional convention to try to fix some issues like this one.
Well, and another ruling that came down that was very big, and that is, to this point, Title IX is only for biological sex, basically saying states can keep trans athletes out of women's sports. That's
right, although there were two cases. And not only does those kind of state laws not violate Title IX, which is a federal law, but the other case involved a claim that it violated the Equal Protection Clause of the 14th Amendment, and in both cases, the Supreme Court said no, it's not a violation of the Constitution, it's not a violation of federal law for states to keep biological men out of women's sports.
Well, to that extent, I know basically if we're going to have the states actually making the decision, then am I correct about that?
Yeah, I mean, it's up to the states to decide what they're going to do about this, except that, the Supreme Court said Title IX doesn't prevent this kind of law, but the Justice Department, has been actually filing suit saying that this is it's discriminatory, that you're discriminating against women if you allow biological men to participate in their sports. So that's a whole nother set of cases that might prevent liberal states like California from putting in laws that allow biological males to participate in women's sports.
Well, riddle me this. How was it that SCOTUS Justice Jackson was able to even make a ruling on it when in her confirmation hearing she couldn't even identify what a woman was?
Well, yeah, you're right about that. But I guess in this case she decided to make an exception.
And we knew it would be coming. But these are the two main cases that came out today, and that wraps up the court for this session around in the hearings. But is there a challenge still available to go back on the birthright issue in the last 30 seconds?
It's very interesting. Thomas said in his dissent that this decision was rushed and he does not think it will withstand the test of time.
That's a very solid point. As always, Hans, I do appreciate your